We'll hear argument next this morning in case 2034-2024. Ms. Brauner.
May I proceed?
Yes, you may.
Chief Justice Lewis, honorable justices, and may it please the court. My name is Lindsay Brauner, and today I, along with my co-counsel, Pooja Gudoor, represent the petitioner, Chris Chambers. Of the two issues before this court today, I will present the first. How New Stork Statute 424 violates the free speech clause of the First Amendment for two reasons. First, the statute is unconstitutional as applied. And second, the statute is content-based and unable to overcome strict scrutiny, making it facially unconstitutional. Your Honors, free speech is of an essential importance to a democracy. And at the heart of that is speech that is critical of public officials, and it must be protected. Your Honors, as to the first issue, the statute is unconstitutional as applied, as petitioner speech falls under both protected parody speech and political speech.
Well, so if I may, what if we don't stipulate to the fact that this is a strict scrutiny case and it's an intermediate scrutiny case? Where are we?
Yes, Justice Lindsay. Even if this court does find that intermediate scrutiny is the appropriate standard to be applied, this statute still fails. As to the first prong of strict scrutiny, we do agree that it survives. However, Milkovich versus Lorraine Journal Company discusses the fact that since public officials naturally expose themselves to increased scrutiny, we must apply a higher standard to public officials.
Does that increased scrutiny include the idea that they must make available or receive communications having to do with their private addresses?
Your Honor, we would not say that it does. However, we would contend that that goes more to the second issue of whether the release of the address was a true threat or not. But
Okay.
as to the first issue, the statute is unconstitutional as applied.
Actually, if I could just understand your statement, your answer to that question. It was your argument for intermediate scrutiny is there is a compelling interest here, but how is that compelling interest outweighed in an intermediate scrutiny analysis? I don't think I caught that sort of half of the inquiry.
Yes, Chief Justice Lewis. That compelling governmental interest is outweighed as the statute, being so broad as it is, includes many types of speech, including parody, as we see in Chris Chambers' speech today, that should get First Amendment protections. As to whether or not the statute is constitutional as applied, we would allege that the statute is unconstitutional as applied.
Counsel, is this really parody when it's Chris Chambers using the insignia of the Silliman Police Department, the name of the Silliman Police Department, and then the language of the police department to indicate that certain police officers are not, in fact, officers? Is that really parody, or is that impersonation as the statute seeks to target?
Justice Ratcliffe, we would say that that is parody. As per page 1006 of Mink versus Knox, when citing Pring v. Penthouse International, the court discussed—
Those are both 10th Circuit decisions. Those aren't binding precedent upon this court. So why should we apply the standard from Minks and Pring, given that it's not necessarily binding on us?
Yes, Justice Beyer. Now, we can rely on this just to look at the standard at which previous courts have determined whether or not speech should be considered parody or not.
Can you direct me to one of our precedents, counsel, that those courts may have been drawing upon and that we can also use to inform our analysis here?
Yes, Justice Beyer. So the courts in Hustler Magazine v. Falwell also discussed the fact that we must look at speech in context to determine whether or not it could be reasonably perceived as fact. Now,
Counsel, though, in Hustler against Falwell, the specific ad was listed as fiction. That seems to be kind of an explicit disclaimer. Did Chambers have any sort of explicit disclaimer on his post here that would suggest to the reader that it's parody?
no, Justice Breyer. While there was no explicit disclaimer, we would contend that in Chris Chambers' changing of the I to a Y in Silliman to change to Silly Man, that in and of itself functions as a sort of
So
disclaimer.
if he had said, if the account had been titled Silliman, no misspelling, do you think the tweet would still be parody under our analysis in that case?
Yes, Your Honor. The tweet would still be parody because it's this paired with many other aspects that amount to the fact that a reasonable person would perceive
And
this
maybe this is where you're going, but what are those other aspects, if you could be as specific as possible?
Yes, Chief Justice Lewis. To begin, the speech that Chris Chambers uses in his tweets is much more colloquial than any speech that an official police department account would use. In the tweet in question today, if I could turn Your Honor's attention to page 4 of the record, it says that these individuals are fake cops, and obviously no real officer would ever do what they did.
Counsel, if you were to write that tweet as you believe the official Silliman Police Department would have written it, what would it say and how would it be different than what Chambers wrote?
Yes, Justice Breyer. Instead of using the term fake cops, it would have used the terms maybe law enforcement officers. Additionally, there likely would be no last sentence that says no real officer would ever do what they did, but rather the actual Silliman Police Department would be likely to say, it has come to our attention that these individuals are impersonating law enforcement officers. Please do not respond to these individuals under any circumstances, as they are not law
So,
enforcement officers.
If Chambers had tweeted that, exactly what you just told us, would we have a different case?
No, Justice Serrani, because even if this was different, the changing of the I to the Y in Silliman, paired with the fact that previous tweets on the
But
account,
counsel, can we really expect, if we're using a reasonable person standard, can we really expect the average American Twitter user who's scrolling through their feed at a rapid pace and not necessarily reading things closely to actually pick up on the fact that the username, not the actual account name, but the username is different, and then to go into the account and then read all of the other several different tweets that are obviously parody? Is the reasonable person really going to pick up on all of these details in just their, their average scrolling session?
yes, Justice Ratcliffe. Now, we're not saying that the burden must be placed on the reasonable person to actually go back and look at past tweets, but we would allege that the reasonable person who is likely a viewer of this tweet living in Silliman would be likely to notice this change, as it's where they're from. They're very familiar with the name. So this change would be likely to catch their eye. Additionally, these individuals...
Counsel, I want to propose a hypothetical scenario where this is the very first tweet that the account is posted. So the account has the same characteristics, same picture, same name, same everything. But this is the very first tweet that the account has ever posted. So there's no previous tweets talking about cops going to donut shops or attack dog demonstrations, stuff like that. Without all of that context, would this tweet, this one tweet, being the first on the account, be considered parody?
Yes, Justice Ratcliffe. Now, the combination of the letter change, as well as the colloquial language used in the tweet, as well as the fact that these individuals have been heavily in the news lately for their notable actions, that any reasonable resident of Silliman would be likely to know what they did and the scrutiny that they've been going through, an individual would be likely to know that these are in fact...
So I think based on the questions that I've heard so far, would it be fair to say that the context alone could determine that this is parody and the text is irrelevant?
Yes, Chief Justice.
So
Lewis.
if this had been a tweet that said, we have this silly man instead of Silliman, right? But it says, maybe it's a carbon copy, it's a copy and paste of one of the official police department tweets. No changes are made. That would be parody?
No, Chief Justice Lewis. We would agree that in that case, the reasonable reader would see that as fact, as they're using the exact language of the Silliman Police
But
Department.
wouldn't they
So-
see the letter change? And wouldn't they be able to know that it wasn't the police department, and therefore it must be some kind of fake parody account?
Justice Ratcliffe, while they still may have seen the letter change, it's the combination of all these kind of clues that hint to the reader that it's parody that clues them into the fact that it's not a factual statement.
Counsel, can we zoom out a little bit away from this particular thing? I mean, one of the real problems we're dealing with, even if we were to rule for you, is, I mean, we don't want to end up in a state where we've just struck down every police impersonation law in the country, right? Like, what is the scope of the ruling you're asking for? What is the rule we should put out?
Yes, Justice Serrani. What we're simply asking is for the language of the statute to be changed from speech to conduct. So, for example, if the language of the statute was changed from actually pretending to be a law enforcement officer to maybe undertaking the duties of a law
Counsel,
enforcement.
doesn't the fact that it only restricts speech if it has the effect of obstructing law enforcement, doesn't that really amount to a restriction on conduct rather than speech, given that it has that effect requirement?
No, Justice Breyer, as it still is regulating speech based on whether or not a person is pretending to be a law enforcement officer.
But this
And
regulation of speech is purely incidental. The statute does not talk about speech whatsoever. It talks about false and reckless impersonation. So how is this not a content neutral law, given that the regulation on speech is purely incidental?
Justice Ratcliffe, the statute is still regulating an individual's speech based on this speech is pretending to be a law enforcement officer and therefore it can be prosecuted under the statute, or this speech isn't pretending to be a law enforcement officer and therefore it can't be prosecuted.
I'd like to
And
return, if I could.
If let's take another hypothetical. Let's say, I don't know, the Chambers, gets, I don't know, a slightly ridiculous police costume, wears it, goes outside, goes to a crime scene, and starts shouting, "Don't listen to them. They're fake cops. They're imposters." Protected? Not protected?
Justice Serrani, we would agree that that is not protected speech. However, that would be prosecuted under the change in the statute that we're asking for, which is changing the statute from being pretending to be a police department to actually undertaking.
I'd like to get at that
I'm
distinction
sorry,
because
if I-
I think I misunderstand, or what is the difference between a police action and a police speech, right? Isn't a police officer giving an order a type of police conduct, and isn't that what's happening here?
Chief Justice Lewis, I see my time is about.
You may, of course.
So as to your question, an individual going and using that speech, while it is conduct because it's undertaking the actual duties of the law enforcement officer by putting on this costume and showing up to this crime scene, which differs vastly.
So how do to me, the way I see it is that when you go online, you're still wearing the uniform, you're still pretending to be the police officer, you're still giving the order or telling people what to do. It's just in a different medium. How could you reframe that to make that non-conduct or non-police activity?
Chief Justice Lewis, these two scenarios differ greatly. As in the scenario we're dealing with today with Chris Chambers simply tweeting from his house, it allows time for counter speech for individuals to look and see, are these actual police officers? Whereas if Chris Chambers had simply showed up to a crime scene and pretended to be a police officer, in that sense, there would be no time for counter speech and could create extremely dangerous life or death situations.
Okay, thank you, counsel.
Thank you.
All right, I think we'll take one moment and then we'll hear from the next issue. Okay, are any of my fellow justices still entering comments on ballots? Ms. Gudoor, whenever you're ready.
Chief Justice Lewis, honorable justices, may it please the court. My name is Pooja Gudoor, and today I, along with my co-counsel, Lindsay Brauner, represent the petitioner in this case, Chris Chambers. Of the two issues presented today, I will be addressing the second issue, that Chris Chambers' conviction under the Public Official Privacy Act, or POPA, violates the free speech clause of the First Amendment for 3 reasons. First, Chambers' speech was not a true threat. Second, POPA is a content-based regulation that does not survive strict scrutiny. And third, POPA is unconstitutional on its face. And to begin, Chambers' speech did not constitute a true threat under the First Amendment. In Virginia versus Black, this court said that true threats—
do you think, maybe if we can take this to the subjective, objective framing that we get in Kahneman, do you take issue with the subjective requirement and think that that's not satisfied, or is it more that this tweet could not be interpreted as a threat?
Your Honor, well, looking at the definition of a true threat, if we look at the statement itself made on page 6 of the record, Chambers stated, "Honestly, somebody should put you in the ground." And while this speech does advocate for violence, if we look at page 927 of NAACP versus Claiborne Hardware, this court found—
Well, I think when it comes to a true threat analysis, I'm very much concerned about the second half of the statement, and maybe they will. That seems to be the part that is really turning the dial on the threat, on the threatening nature of the statement.
Chief Justice Lewis, yes, he does say maybe they will, but this statement, yes, it's advocating for violence, but this court has previously said that mere advocacy of the use of violence does not remove the First Amendment.
What if it says something like, maybe I will? Would that still be on the advocacy side or the threatening side, as I think you're drawing it?
Your Honor, in that case, we would still allege that that would still be not simply advocating for violence, because if he had made a more definitive statement like, "I will do this," then in that case, we would say that is a true threat. But if we look at page 9 of the—
So I guess just maybe this will be my last question for a few minutes, but when we're, John Q. criminal on the street, here's maybe our advice. Whenever you want to threaten someone, use the hypothetical mood and speak to them in terms of what you think should happen, would happen, could happen, instead of being direct with it. And as long as you do that as a criminal, you'll be safe. Your words will be off limits. That's I guess the consequence of what I'm hearing from you, and I'd like to hear you address that.
No, Chief Justice Lewis, of course, that does not simply exempt any criminal from any action they might take by using that specific tense. But if we look at page 9 of the record, Chambers stated, "Look, obviously I'm not going to do anything." And if we look at page 932 of Claiborne—
I mean, did he say that in the tweet? Did he say that to Pigeon? I don't think that we can simply take that private communication as, diminishing the threatening nature of his statement, given that that statement was not available to the officer Pigeon at the time that he would have encountered and read the tweet.
Justice Breyer, to that we would respond with page 932 of Claiborne, where the court said that the public statements themselves cannot be the sole proof that they were true threats. It's clear in these private messages that Chambers stated he didn't—
But I think it may say that, right? But I think that's more about context is important. But are you saying that we have to consider context that was unavailable to the recipient of the threat?
Justice Serrani, we must consider all the evidence that's available. So if we look at these private messages—
Yes?
Yes, Your Honor, that would be a yes, that we have to look at this because we have to look at all of the evidence.
So if I post on Twitter, "Hey, Chief Pigeon, I'm going to kill you at 10 p.m. tonight at your house. Here is my gun," and then I send a text that says, "I'm obviously not going to do anything," to my friend, is that fine?
No, Your Honor, that would very clearly be a true threat, as that's giving the specific information of what exactly is going to happen, and it's a definitive statement. However—
But the point here is that we
may.
have to look to that text, right? And it seems to me that in my case, the text doesn't change anything. And so I'm trying to understand, why does the text matter in our case, but not in my hypothetical?
Your Honor, we have to look at the context of all of the evidence. So in your hypothetical, the speaker would be giving the statement of, I will kill you at this time and do this XYZ, but he's still saying, look, obviously I'm not going to do anything. However, that greatly differs from the case at hand because Chambers' statement essentially was vague in nature and there was no specific information given. And furthermore, if we do look at the context of the threat, because in
Well, speaking of context, it looks like, someone was just assassinated in this town. There are a lot of very serious concerns regarding the safety of public officials. So isn't that part of the context that we should look to? And wouldn't that weigh in favor of interpreting this as a true threat?
not necessarily, Your Honor. If we look at the context that we're provided, with Pigeon himself, Chambers had no known propensity for violence and no violent history with Pigeon himself that indicated that something would actually happen. But if we do
So,
look,
counsel, it seems to me to be a very convoluted standard that, if someone is already a criminal and does not use the hypothetical tense and does not text someone privately later that they were kidding, then what they're doing is a true threat. But all of these things seem to be very circumstantial and very conditional aspects of this case that do not really provide us a good standard for future cases. So you're saying we got to consider all of this context, but at the same time, different aspects of the I'm not really sure what the standard is you're setting here. If you could explain that as clearly as you can.
yes, Justice Ratcliffe. So if we look at page 367 of Virginia versus Black, the court said that we must consider the contextual factors. So if we look at the case at hand, first looking at the statement that Chambers had made, his statement was essentially vague in nature and it was not.
It wasn't vague when he posted the exact address where the chief of police lives. I mean, why did he do that if not to threaten him?
Your Honor, we can see that Chambers said in the private messages that it was just to give a scare and that nothing was intentional to happen. And as such, we have to consider this in light of the Claiborne ruling and see that Chambers did not intend.
When we're talking about intent to give a scare, I just want to ask, what about this tweet could possibly be scary if not for the threat of physical violence? Like what if we're going to read this generously to Chambers? Oh, what's he trying to scare Pigeon with if not violence?
Your Honor, in the case at hand, we do not know exactly what Chambers was thinking. However, if we do see, we need to look at the account itself and see that this was just a humorous and parody account that had just provided comment.
He's trying to give a scare, and so humor aside, I don't think humor is generally meant to be scary, right? What is he trying to scare with?
If you had to speculate.
What's he threatening?
Your Honor, if I had to speculate, then I would just say that Chambers was just trying to make a comment about what had happened and in regards to his arrest. So while we cannot definitively say, that is what could be inferred.
I wonder if I might ask you to step back for a moment and think both about the Falwell decision and the Brandenburg decision and contemplate what might be an apparent contradiction, or it maybe not so apparent contradiction. That is that in Falwell, ultimately the court, Justice Rehnquist, I believe, concludes that opinion, this is a libel case, but that opinion is always protected, essentially. And in Brandenburg, then, there's a kind of incitement standard that may or may not include opinion. I guess on your side, though, wouldn't it be the case that if the reasonable viewer of all of these tweets realized it was opinion, that it would automatically be protected at that point?
Yes, Your Honor, and that is what we are contending, that Chambers' statements were protected under the First Amendment.
And regardless of, you need not reach Brandenburg, you need not go to Brandenburg. You can say, obviously, this is parody because it's opinion, it cannot be fact.
I'm sorry, Your Honor, could you clarify what the question
Well, I
is?
mean, you don't even have to go to a Brandenburg true threat analysis, do you? If you come to the conclusion early on, reasonable person would say this is opinion. and an
Yeah.
opinion is always protected.
Yes, Your Honor, you could definitely say that, and we do concede that. However, if the court does want a true threat analysis, then we would still find that it does not satisfy a true threat.
Could you actually speak to incitement? Well, I mean, I think part of what you're saying is that at worst, this is a call that pigeons should be subject to violence. Why isn't that incitement?
Well, Your Honor, in the case at hand, we can see that Chambers' statement did not incite imminent and lawful action. He said, maybe they will. So he was not directly inciting anyone to do anything.
Doesn't the
Now,
address kind of bear on that though? Like, what are you asking for if not to either convey a threat or say, hey, look, people, go to this guy's house and screw with him?
Your Honor, we must also look at the statement that says maybe they will, because with incitement, we have to for example, the speaker would give a time and a place, and that would incite the imminent lawless action. With the use of the word maybe, we can see that it's not imminent.
But counsel, can we at all believe that the use of maybe is actually an indication of Chambers' intent? I mean, the dude is angry because he was arrested for what he believes is something that he shouldn't have been arrested for. I mean, if someone does something bad to me and I say maybe I'm going to kill you, I don't think that indicates anything about my intent. That's just me trying to. That's just using language to send a message. It doesn't necessarily convey that I have less intent to do something. Can we really take that maybe at face value, especially given that any reasonable observer is going to read that and see this guy's pissed off. He wants something to happen.
Justice Ratcliffe, we need to take that maybe with the entire statement at hand. So Chambers did provide the address, but he did not provide a specific time or place for people to go and possibly kill Chief Pigeon. And
why would he have to? Why would he have to provide a specific time and place? He said someone should probably go and do something violent. Here's the place. Here's the person. Here's the reason. Why does he have to? Why does he have to plan it out specifically in order for it to be incitement? Because I mean, he doesn't have to surely draw up a whole battle plan in order for this to actually be incitement to violence.
Also, it's his house. He's usually there, yeah?
Yes, Your Honor, but to satisfy incitement, it would have to be imminent lawless action. And again, with these potential statement or hypothetical statement, we can see that nothing directly was being initiated to occur. Furthermore,
so I just want to ask one more question on this subject. You say there was no incitement to imminent lawless action. Okay, that's a claim that can be interpreted, but the argument against that is that lawless action did indeed occur imminently. Subsequently, following Chambers' tweet, people did go to Officer Pigeon's house, did commit acts of vandalism, and did threaten his life. So doesn't that show that the claim you're making and that Chambers didn't incite is just falling flat? It happened. I mean, we can't question that.
Your Honor, I see my time is elapsed. May I briefly
Go ahead, counsel.
So, Your Honor, while people did go and do the vandalism, it's important to note that we have to look at Chambers' intent. And we can see that in the private messages, which the Claiborne ruling tells us that we must consider, that Chambers did not intend for anything to happen. So for the aforementioned reasons, we ask this court to reverse the rulings of the 5th District New York Court of Appeals. Thank you.
Chief Justice Kyle?
Yes? All right, unless anybody's still working on their ballots. Mr. Wang, whenever you're ready.
Of course. Chief Justice Lewis, and may it please the court. My name is Alex Wang, and I, along with my co-counsel, Ms. Siying, rise today on behalf of the respondent, the state of New York. I'll be addressing the first issue, how the police impersonation statute under Section 424 is not in violation of the First Amendment, and Ms. Tell will be addressing the second, how the anti-doxing restriction under the Public Officials Privacy Act, or POPA, is also not in violation of the First Amendment. Your Honors, police officers and law enforcement go through vigorous training to ensure that the public is defended by those capable of doing so. But today, the petitioner is asking this court to find that just anyone, regardless of how obstructive or dangerous, has a right to impersonate public servants. Your Honor, ask this court to affirm the lower court's ruling that Section 424 is not in violation of the First Amendment for 3 reasons. First, that Chambers tweets are not protected parody. Second, that intermediate scrutiny, not strict scrutiny, is a correct standard of analysis, which the statute satisfies. And third, that even if strict scrutiny were to be applied, the statute survives regardless. But on to my first argument, Your Honors, that Chambers tweets are not protected parody. For over a decade, it's been precedent from this court's ruling in United States v. Stevens, cited in Counterman, that there are permitted restrictions upon the content of speech in a few limited areas, one of them being parody. And we can engage with the standard
hang on, if I'm hearing you correctly, you're suggesting that parody is somewhere where you are permitted to restrict speech. That's one of the exemptions from the First Amendment. Is that what I just heard?
Chief Justice, so we're saying that parody is one of the exemptions when it comes to prescribing speech. In other words, parody is protected speech, even if it were for some other reason prescribable in another context. But that standard of analysis in determining whether something is parody or not would draw to the Milkovich standard, which is whether or not, if a statement cannot be reasonably interpreted as stating actual facts, that's protected parody.
Counsel, doesn't that apply to, I mean, most speech that one would encounter on a Twitter feed? I mean, does any reasonable person really log into Twitter expecting to find statements of fact in their feed? That doesn't seem like a very reasonable thing to do.
That could be the case, Justice Breyer, if we're applying the Milkovich standard in another context. But in this context, if we were to apply the standard that simply we were to look at whether or not if a statement is reasonably interpretable to be true, and that if it is, it's not protected parody. In that context, Your Honor, in this case, Chambers tweets, it's not protected parody because it is interpretable reasonably to be true. And petitioner points out many, many examples of how, for example, the parody is.
So actually, I have an example of my own that I think is very pressing that I'd like to hear you address. And that's the final sentence of the tweet says that no real officer would ever do what they did. I think anyone in this country who has been alive in the last 10 years, especially in the year 2020, is very aware that police officers do this kind of thing all the time, constantly. And so to say that no police officer ever does this, I think contradicts something that everyone knows. And to me, that's a strong indication that no person would reasonably take, no person would be reasonable in taking this as fact. And how do you address that?
We would disagree with that, Chief Justice Lewis, because if Chambers is trying to impersonate a police department, obviously a police department would try to defend police officers, or in this case, the police department, and claim and assert that obviously no real officer would do what they did, especially given the context of what happened in 2020, and especially because there's so many instances.
Right, I guess that's what makes it, to me, a good parody, right? Is that people would believe that this is what a police department would do, but it looks ridiculous and it's unbelievable. And that's, no person would take it to be true, and it's skewering police departments precisely for defending their officers against every allegation that we've seen in the last 10 years and who knows how many years before that.
Well, the issue here, Your Honor, is that we're still asserting that it is reasonably interpretable to be true, given the entire holistic assessment, where it is still reasonable for a reader to understand that a police department or a police department's official account might post something like this.
So just to pin this down, you think a person could reasonably say, oh, I'll take it to be the truth that no officer would ever do this?
That's incorrect, Chief Justice Lewis. We're saying that it's reasonably interpretable for a reasonable person to assume that a police department, an actual police department, might post something like this.
Just to be clear, is the standard you're putting forward that the test of whether parody is protected is whether a reasonable person could receive it as actual fact, or whether a reasonable person would?
Or whether a reasonable person would assume that to be true. But it's important to understand that it's not.
In this case, right? I mean, like, as far as we understand, right, the vast majority of people who saw this tweet did not fall for it and end up creating an obstruction of law enforcement, right? I mean, to the extent there's a difference between would and could, it seems like on the would side, a lot of people didn't fall for this and kind of just chuckled.
Well, that's absolutely correct, Justice Ronnie, that many people didn't. But it's also true that many people did fall for this. The record is very clear about this.
Well, it looks like
Okay.
only, a few people out of the many thousands who saw it actually, disobeyed police officers and cited the post. I mean, are we really counting that small minority as reasonable people and not say, an unreasonable minority of people?
And
We'll
to add to
disagree.
that, are we then labeling the majority unreasonable?
No, Justice Ratcliffe and Justice Breyer, we would disagree with the premise of that question because the record is very clear on page 5 that it wasn't just a few people. In one instance, there were crowds of people who misinterpreted those statements and disobeyed those
But
officers.
that was not the statement we're talking about. That was a prior statement. You're not prosecuting Chambers for his entire account or for every statement he's ever made. You're prosecuting Chambers for the specific statement about these people being fake cops, which, if I remember correctly, there was fewer than a dozen people who actually believed that and then didn't end up obeying those police officers. So I don't see why those previous instances matter at all.
That's correct, Justice Ratcliffe, hence why we can engage in some form of de novo review. Petitioner attempts to claim that that single letter change or the colloquial tone is a giveaway that it's parody, but that's, again, an error in their analysis. On to the first part about the single letter change. As Justice Ratcliffe, as Your Honor correctly points out, it's unreasonable for us to assume that the average reader who's scrolling on Twitter would be able to notice that subtle change, given that that's actually on the handle of the tweet, not the actual account, the official, the badge, or the actual name of that. And onto the colloquial tweet, the colloquial tone of that account. As we all know, the world and social media certainly is attempting to appealing more and more to younger generations. And it would make sense for us as readers and certainly for the department to attempt to be more colloquial in that manner.
If I could,
If
Justice
he
Breyer, of course.
begun the post with a phrase like "Howdy everyone" or something that's not mimicking the "Please be advised" or not mimicking the official post, then would that be parody?
If it was specifically say howdy everyone, that would not automatically make it parody because that could simply be a greeting. But depending on the context, say it was very blatant. Something like, good morning, folks. Happy breakfast evening on a sandwich to you. That perhaps would change the calculus of things, Justice Breyer.
I'm still interested in this idea that I brought up with your colleagues or your friends about parity and the Falwell decision. If, as is often the case when people read tweets, that it was assumed that this is just one guy's opinion, how then is it not protected?
Well, Justice Milkovich recognizes and asserts that there is nothing as a constitutionally protected opinion. And the reason why the reader would not assume it to be an opinion is because the entire account is based off as a police department account. It's not just an opinion because he's trying to impersonate the actual thing. And to the reader,
Counsel, I want to go back to something you said earlier about how it's reasonable to assume that the police department would want to use some sort of colloquial language in order to appeal to the youth. This seems to me to be a rather, pathetic attempt to cordon off certain kinds of speech so that the government can, if it wants to appeal to more social media followers, get more following by using certain speech. Therefore, we are limiting the content of parody accounts so that the government can get more followers on social media. That does not seem to me to be a compelling reason for limiting someone's ability to produce speech just because the government might at some point use colloquial phrases.
we would disagree with that analysis respectfully, Justice Ratcliffe. We're not attempting to assert that because the governments can be more colloquial in tone, that all parody that is colloquial is not now a clue. And that given a totality of the circumstances analysis, petitioner's argument that this colloquial tone is sufficient, along with this single letter change, to automatically make the reader assume that it's parody is simply not sufficient. We're not attempting to vary a new rule in that case, Justice Ratcliffe. But as we know, context is critical, and Counsel for Petitioner, my friend on the other side, points this out very importantly. And it's important to know that this tweet exists independently of other tweets. It's on a Twitter feed. It does not include the plethora of, as we concede, more absurd and parodic tweets in nature of Chambers' account.
Counsel,
They are viewing this
I want to ask you, okay, like if you could give me the conditions, what could Chambers do? How could he rewrite his tweet so that it would be parody?
a few things, Justice Ratcliffe. The first thing is not just the tweet specifically, but he could change his account to be more parodic in nature. They change a name, or to something more fancy, or not fancy, but parodic in nature. But regarding the actual textual basis of the tweet, could have written something like more blatantly obvious. Obviously, no real officer would do what they did because because officers spend time eating donuts all day or something along those lines. Because that simply is not sufficient, because it could be interpretable to be true in that case without some kind of more
Counsel,
drastic.
Counsel, this all sounds to me like the government is trying to get in the business of regulating what is comedy and what isn't. Like this seems to be setting a very strange standard to me, where we can say it's only parody if it's so ridiculous that we think it's actually funny. But this language is too close to what we might want to say because we want more social media followers. Therefore, it's not parody. This seems to me to be a dangerous standard for the government to be able to regulate the content of parody accounts and parody productions.
We would respectfully disagree with that premise, Justice Ratcliffe, because we're only discussing the content here. Because in the condition that the context, in this case, the Twitter feed, and the other context regarding the actual profile photo, the name and badge are identical. Otherwise, usually parodic tweets or parodies would have those as clues and disclaimers. The Onion certainly doesn't just post tweets mimicking the actual thing.
To me, it seems like there's really the thing that makes this case more serious is that there's a political aspect, and the fact that he's talking about a serious subject, the fact that he's taking a particular tone, then maybe we should give that more protection, because people in New Stork are having this conversation, and why should we allow the government to intervene in this particularly heightened sense when the conversation is political, right? I mean, we could take all of these things as an indication of that being what's happening, and I'd be concerned by your position that we would be intervening improperly in that case.
Well, Chief Justice Lewis, the reason why this is a bit different is because it actually has a danger for incitement or obstruction of law enforcement. If it removed the obviously don't obey these officers, that would be political speech, and certainly that could amount to new protection if that rule.
Counsel, I'd be concerned about drawing a distinction between, speech and the effect of speech. I mean, to give a hypothetical, let's say that someone is, advocating for a boycott, and, New Stark passes a law that says you can't advocate for a boycott if that has the effect of harming our city's economy. Would that be a constitutional law?
That would be that would not be an unconstitutional law, Justice Spire, because that's different in this case. Economic impacts are different from obstruction of law enforcement, which Section 424 regulates.
Why? As a constitutional matter, why are they different? Is it because the interest is different? What's the, constitutional difference between those two objectives?
The difference, Justice Spire, is because there could be more effective and less restrictive alternatives when it comes to minimizing or mitigating economic damage, while in this case, Section 424 regards the case of obstruction of law enforcement. This, and moving on to my second argument, is that intermediate scrutiny is correct standard of analysis because it is already proportional in that matter.
If I could just ask one more question about parody, and I'm sorry to do this, but I'm processing your argument that if he were to remove the call to disobey officers, then the tweet would be parody. Am I understanding you correctly there?
That's incorrect, Chief Justice Lewis. That was a response to your question regarding heightened protection from political speech.
Right. So if he were to remove that statement, it would still not be parody, is your argument?
It still wouldn't be protected parody if nothing else changes. That's correct. No, so moving on to my second argument
I'm sorry to keep you on parody, but can I ask you one more hypothetical? And I guess this one actually happened, which is there was a Twitter account that purported to be the pharmaceutical company Eli Lilly and Company, which bought the Twitter verification and posted insulin is now free, and at least purportedly as a commentary on the greed of pharmaceutical companies. Accounts otherwise completely indistinguishable from the real pharmaceutical company. Is that protected parody?
That's not protected parody because it's not reasonably interpretable to be false, but that wouldn't come under any statute, at least not in the record, because there's no obstruction that's caused. And in regards to Section 424, that limits obstruction of law enforcement. That post would certainly not limit or cause an obstruction.
I mean, assuming there were a law enacted, I don't know about like corporate impersonation or something, that in your view is not a permissible way to make social commentary on greed of pharmaceutical companies.
Well, if there was nothing in to suggest that it was parody, if it actually already bought a Twitter verification, the exact account name is the same, there is nothing else to suggest that would be parodic in nature, then that certainly would not be protected parody. But whether or not it would come under a statute would depend on the statute. And for the foregoing reasons, we ask this court to affirm. Thank you.
Thank you, counsel.
Your Honor, may I proceed with the argument on issue 2?
Just one moment, please.
Yes, Your Honor.
As soon as we get Justice Breyer back on screen, I think. Okay, Ms. Tao, whenever you're ready.
Yes, Your Honor. Honorable Chief Justice, and may it please the court. My name is Siying, and I'll be continuing the argument on the second issue on how Chris Chambers' conviction under the Public Officials Privacy Act, or POPA, must be affirmed. The First Amendment protects a right central to our democracy, which is the right to free speech. However, free speech cannot exist without its limits to help ensure safety and privacy, especially in the online space, where malicious spread of information and cybersecurity risks can cause severe physical harm to victims.
I wonder how,
Therefore,
if I may ask a question, how do you define the privacy rights of a public official?
Your Honor, private information of a public official is defined by POPA as including their home address, their phone number, their social security number, their biometric data, and a list of things that can identify the public official or the individual.
No,
And
I don't mean it so much in terms of what is specified in the statute. I mean, in terms of what we might reasonably think under the First Amendment as to what kind of privacy rights a public official has. Isn't the public official really, don't they, as a matter of public responsibility, open themselves up to a really less private zone of possible communications?
Your Honor, respectfully, we would like to disagree that public officials' private information should be less protected, because oftentimes what public officials do as their job is very controversial. For example, taking the example of the chief police officer, Alexander Pigeon, some people may agree with his actions and some people may not. And those who do not agree with his actions may cause violence and harm to his...
Counsel, if protesters held a rally, let's say, outside of his house on a public street adjacent to his house, and if they said, oh, if Chief Pigeon doesn't end police brutality, then we'll end Chief Pigeon, would that be, a true threat that the government could criminalize?
Your Honor, that would, since it's peaceful protest, then that would not be a true threat. But it depends on what is the intention of the protesters and also whether the chief police officer has perceived any threats. For example, well, if the protesters had the intention to make a true threat and to cause harm to the chief police officer, and the chief police officer actually felt scared, then that would be a true threat, which is similar.
Counsel, how do we counsel, how do we determine intentionality? Because your opposing counsel is pointing to the text that Chambers sent afterwards, to the language he utilized, saying maybe as opposed to definitely, also referring to his state of mind. How do we establish that? How do we establish the intentionality behind a statement in order to say whether it's a true threat or not?
Your Honor, obviously we cannot know what the speaker is thinking. However, from their words, we can determine whether they mean a true threat or not. And in this case, Chambers' tweet states, "Someone should put you in the ground," and maybe they will.
Well, counsel, doesn't the word "they" suggest that Chambers himself is not intending to commit the act?
Your Honor, a simple
And further, doesn't someday under a Brandenburg standard indicates that there's no probable causal connection?
Your Honor, Chambers' statement does not say someday or whatever time that the violence should be committed. And furthermore, that we cannot interpret using the use of third person that Chambers does not have a personal intent. And that is because everyday speech is rich and complex. Therefore, meaning is often blurred and we need to read in between the lines. For example, we can take the statement of snitches get stitches. If a speaker said snitches get stitches to their victim, we would of course interpret that as a true threat because we all know that snitches get stitches means a true threat. However, the statement does not say who is the person that's going to commit harm, who is the victim, and what harm will be committed. And therefore, we need to consider the context in this case. Since
Counsel, if he had just posted the address, with no statement accompanying it, just posting the address, as I understand it, that would be illegal under the POPA, or it could be. Would that be considered a true threat?
Your Honor, we would respectfully disagree that it would be illegal under POPA due to POPA's intent requirement under its Section 2A. Since
Well, counsel, let's say that someone did have the intent. Chambers does want to frighten Pigeon, but all he does is post the address. No statement accompanying it, just post the address, but he does intend to intimidate and frighten Pigeon in doing so. Is that a true threat?
Your Honor, in that case, Chambers or whoever the speaker is would have no show of their intent to intimidate, and therefore they would not come under POPA.
Well, what if we have private messages saying like what Chambers said in this case, which I'm assuming is part of your argument for why this is a true threat, because he said, I just want to scare him. So Chambers sends out the address, nothing else. This is just like, this is Chief Pigeon's address, blah, blah, blah. Later in private messages, he says, I want to scare him. Would that be a true threat? Would it be illegal under POPA? Those are two separate questions that I think we'd like you to answer.
Your Honor, first of all, it would not be a true threat because we need to only consider the evidence available to the recipient of the message, as Justice Serrani has previously questioned, such as Chambers' messages to friends should not be considered to determine whether Chambers' statement caused a perceived threat.
Right, but I think what we're talking, and I believe what Justice Ratcliffe, not to speak for him, is talking about is the intent requirement within POPA, which does require us to look into the mind of Chambers, and it's not necessarily, even if it's not necessarily towards the determination of a true threat.
So is Your Honor asking whether Chambers held a reckless intent to threaten?
I think we're still in the hypothetical of, let's say he had just posted, this is Chief Pigeon's address, 44 Lagoon Road or whatever. And he had the intent internally to, make this guy's life very bad and have people protest and vandalize his house and intimidate him, as determined by internal text. That seems to violate POPA, or am I missing something?
Well, yes, Your Honor, that does violate POPA. The problem is we would fail to see how this could occur in real life, since it is impossible to determine what someone is thinking internally without their actual speech or expression that they had.
Well, then, counsel, doesn't this point to some severe problems within POPA then? If we're determining if it's about intent, someone could distribute Chief Pigeon's address and we have no clue why they're doing it. They can just send it out there. But then if people start, protesting, vandalizing his house, then the question is, oh, did that person have the intent to cause this? And then we have to start investigating and trying to figure out what was their intent. Was it this person's fault that people, I don't know, smashed windows up at Chief Pigeon's house in this hypothetical scenario? So, POPA requires that anytime someone posts any of this information about a public official, you have to examine their intent and whether or not they intended to do it for these malicious reasons. So doesn't that point to a flaw within this law that requires us to perform an impossible task?
Well, we would disagree with that, Your Honor, because say if someone were to prosecute another person under a POPA, they would have to show some sort of evidence and demonstrate that the speaker actually had the intent, the malicious intent. And therefore, that would not.
Counsel, counsel, I guess what I'm getting at here is that it seems impossible to do that. It seems impossible to demonstrate that intent in certain cases in the hypothetical scenario we're proposing. And it just seems like POPA is trying to censor speech that might, cause problems for public officials, and this whole intent aspect of things just makes it impossible to actually enforce that.
Well, Your Honor, we would believe that this is more like an under-inclusivity problem rather than an overbreadth problem, because in the hypothetical example where someone somehow had the intent to threaten and published a home address, but did not actually express that in their speech, then POPA could not limit that because the prosecutors that prosecute.
Counsel, doesn't under-inclusivity pose a constitutional problem for you? And under-inclusivity can demonstrate that this law is not, narrowly tailored to avoid infringing on speech. And I think these came up in the dissent down below, in the court below. So isn't it still an issue for us if this law is under-inclusive?
No, Your Honor, we would respectfully disagree with that because in RAV versus St. Paul, it is stated that it's not an under-inclusivity issue, but rather a content discrimination issue. So if it was under-inclusive, then there could easily be another statute passed to do whatever was not included.
Counsel, before we get any further into this strict scrutiny, narrow tailored inquiry, I do have a couple more questions about intent, sort of not the as applied question of whether chambers had the intent, but broadly the statute's language. So do you think that intent to inflict harm on someone's political reputation, say the objective requirement of a true threat is satisfied, do you think that intent to inflict harm on political reputation would be sufficient for a true threat?
Your Honor, in that case, that would not be sufficient for a true threat.
Okay, and what about threat to someone's or intent to inflict harm on someone's property value? Assuming that an objective person reading this statement would think, oh, that's very physically threatening. If my intent was related to property value, would that be a true threat?
Your Honor, if the threat was not directed at a person, then that would not be a true threat.
Well, so maybe it's a threat to a person's property, right? I wish to harm them by reducing the value of their home by spreading rumors or by calling for people to come and egg their house or dig up the garden or something like that. That's not violence to the person, but some or even just some kind of nuisance, right? That would decrease the value of the property, right? So my intention is to create that kind of problem, still a harm to the person, but through the lens of their depreciated property value. Would that be a true threat?
Your Honor, in that case, it would depend on two things. First of all, Your Honor stated that the person wished to cause harm to the person by infringing on their property, and that does constitute a true threat. However, it also depends on whether the person has perceived a threat of physical harm. If someone were to tell...
Right, okay, so just with the subjective requirement in mind, I mean, my issue is that POPA seems to include, and maybe you do think that this is a true threat in the property case, right? But harm to someone's political reputation, that to me, by POPA's language, seems to be included in the kinds of intent that would be criminal. But that doesn't, to me, seem to be a true threat. And because we have that misalignment, I think there's an overbreadth problem.
Your Honor, political speech is different because political speech is often very heated, and when examined in its context, it's often doesn't mean the thing that the speaker is explicitly stating. For example, there's an instance in, I remember it was NAACP, in which someone actually expressed the will to threaten the life of the president. And that was not considered a true threat because under the correct political circumstances, the person was merely expressing their opposition, their political opposition to the political stance of the president. And that is what...
So I think just on the true threats analysis, if a person does not understand their statement to be making a threat of violence, physical harm, but everybody else in the world does, right? This is sort of maybe they just said the wrong thing, or they said something that, it came out in a way they didn't intend, right? But that seems to me to be a crime under POPA, but not a true threat. And that, I think, is the problem that I'm trying to hone in on here. Not a statement where, it's a political context where a person is speaking exaggeratedly, but really where there's a difference in their subjective intention here. And how do we know that's not what's happening here?
Your Honor, if someone did not have any subjective intention, even the reckless subjective intention to to express a true threat, then they would not be punished. Then that would not be a true threat, because under the ruling of Counterman versus Colorado, someone needs to have at least the reckless intent to threaten the person in order for it to.
Counsel, I think sort of in extension of the Chief Justice's question, I think the issue we're getting at is that there seems to be a problem that, POPA is interfering with speech that is traditionally protected. It is traditionally protected for someone to be able to distribute the address of a public official. And what POPA would do is make that criminal if there is any way to determine that that person intended for that public official to be made uncomfortable. And that's not a true threat. So POPA is regulating speech that is not a true threat. How can POPA not be overbroad if it is touching this kind of speech that is traditionally protected?
Your Honor, seeing that my time has elapsed, may I answer the question
Of course,
and
counsel.
briefly? In that case, Your Honor, well, POPA is still allowed because although there are certain prescribable modes of speech that can be limited or controlled, it is not only those types. And here, POPA, it is, first of all, it serves a compelling state interest to protect the safety of public officials. And secondly, it survives strict scrutiny because POPA is not overbroad, as it only punishes the speech in which the person has a malicious intent to harm, and any person who publishes private information of public officials with the intention to harm, they will actually cause a harm to public officials. And for the foregoing reasons, we ask this court to affirm. Thank you.
Thank you, counsel. Okay, and as soon as time is ready, petitioner, you may begin your rebuttal.
I have just a second.
Of course, just let us know.
All right, ready. Sorry about that.
May it please the court. Justice Rehnquist once said, "At the heart of the First Amendment is the recognition of the fundamental importance of the free flow of ideas and opinions." Your Honors, both POPA and Statute 424 are unconstitutional for two reasons. First, Chris Chambers' speech is both protected parody speech and political speech, making Statute 424 unconstitutional as applied. And second, POPA is not a true threat. And because Chris Chambers' speech is not a true threat, and because it was prosecuted under POPA, shows how POPA is overbroad. Turning to the first issue, and as to Justice Byers' question to respondent, no reasonable individual is logging into Twitter expecting to find factual information. Twitter is a platform that is known for misinformation and parodical tweets such as this.
Counsel, but I don't think that we can claim that's true. I mean, putting aside, surveys that say people actually get their news from social media sites, government agencies are on Twitter. I mean, that's why this is an issue. Government agencies are on Twitter and they post things that are important, sometimes emergencies. So yes, people do expect to get facts from Twitter from certain things that include something like a police department. So, I mean, Chambers seems to be impersonating the very thing on Twitter that might actually give you facts.
Justice Ratcliffe, while we do concede to the fact that there is some true information on Twitter, the fact that this speech was posted on Twitter in the first place is likely to make the reasonable individuals skeptical going in. When they're going in, they realize that they're on a social media platform well known for misinformation, and that what they're seeing might not necessarily be true. Additionally,
So when a person sees a real government agency Twitter account, do you think that they would have the same skepticism?
yes, Chief Justice Lewis.
And do you think that that skepticism would be overcome by the real account?
Yes, Chief Justice Lewis. When further looking into the account, seeing the account name, the username, the real previous tweets.
So counsel, if Chambers had hacked into the Silliman police account and made this same post, would you say that is something that the reasonable reader would recognize as parody, or at that point, would it no longer be reasonable to see that as parody?
Justice Beyer, if he had hacked into the account, at that point we would concede that the reasonable reader may view it as fact, as the context of the tweet would appear to make it factual. And
Counsel, if I could, I'd like to direct our discussion briefly to the second issue. In response to a point that your co-counsel made, about how, Chambers tailored his language to say maybe it was conditional. There was not that much of a demonstration of intent. Yet we have the problem that people did commit acts of vandalism. So if Chambers did have this intent to conditionalize and to limit his, the extent to which he's calling for violence, why didn't he tailor his language more carefully? Why didn't he explicitly say, when he said maybe someone should put you in the ground, maybe someone should, but I'm actually saying that I'm actually not advocating for violence? If he had this intent, why did he not fully show it as much as he could have?
yes, Justice Ratcliffe. And we would allege that that Chambers did not have the intent to carry out this threat. And that was, Justice Lewis, may I briefly complete answering the question and then conclude?
Briefly, counsel.
And that was portrayed in the private messages where Chris Chambers discusses that he actually had no intent to carry out.
Counsel. So I guess my question is, if he actually had no intent to carry out violence, and he had no intent to inflict fear upon Chief Pigeon or in a reasonable manner, why didn't he say that publicly? Why did he just say it privately?
Justice Ratcliffe, while there is no way to know exactly why Chris Chambers acted in the way that he did, he explicitly stated that he had no intent to carry out this threat. And that, combined with the vague language, the third person language he used, shows that there was this lack of intent. So we ask this court to reverse the findings of the 5th District New Store Court of Appeals and find both Statute 424 and POPA unconstitutional. Thank you.
Thank you, counsel. The case is submitted.